Welcome back to LaStash channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to discuss whether the Fourth Amendment protects your privacy interests in a tent located on a public campground. And when I say privacy interests, we're going to discuss both an arrest and a search of a tent. And before we go on, I want to thank you for watching me on YouTube. If you like this channel, please subscribe, hit that bell notification button so next time I post, you're the first to know. And of course, share it with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to LawStash.com and check out some of my merch. Thanks for watching.
Quick message from LawStash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LawStash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LawStash YouTube page. That's LAWSTACHE.
Today we'll be discussing a Ninth Circuit case, United States v. Guch. Let me give you a quick summary of the facts. Around 3:30 in the morning, a woman calls the police and says there was a fight between two men and allegedly Mr. Guch shot at this other individual. Nobody was hurt, but of course shots were fired. Officers respond to the scene, but they arrive a few hours later. This is now 5 a.m. in the morning. It is bright outside, and the officers later testified that it was peaceful and quiet at the campground. The officers then determined that Mr. Guch was now sleeping in his closed tent at this public campground. And by the way, he's been living at this tent for the last few days, and he didn't have any other residents. The officers, without seeking an arrest warrant, open up the tent, get Mr. Guch out. They pat him down, handcuff him, and arrest him. Following the arrest, they now again don't have a warrant to search, but they still go into the tent and they find a firearm. Now, both of these items were done without a warrant. The state charges were later dismissed, and Mr. Guch was now facing a federal indictment for being felon in possession of a firearm. Now, he of course tried to suppress the items that were found, the firearm, saying that it was illegally found in violation of the Fourth Amendment. The Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search or seizure. And like I said previously, in this situation, they did not have a warrant. The first question when we discuss the Fourth Amendment is always whether this is a governmental search or a private search. The Fourth Amendment does not protect you against private searches. That's called the private search doctrine. I've discussed this doctrine many times on my channel, and I encourage you to go back and watch some of those videos. Here we don't have that issue. Of course, the first question is answered easily, that this is a governmental search. We're dealing with the state police. The next question, of course, is whether the Fourth Amendment protects your privacy interests in the tent. In order to show that it applies, Mr. Guch would have to show both a subjective and objective expectation of privacy in his tent. This comes from the Supreme Court case Katz, which developed this test, called the Katz test or a reasonable expectation of privacy test. The Ninth Circuit says that we have previously established that a person can have an objectively reasonable expectation of privacy in a tent on private property. This reasonable expectation is not destroyed when a person's tent is pitched instead on a public campground, where one is legally permitted to camp. The Fourth Amendment protects people, not places. The government tried to compare this case to other cases involving mobile homes. I have previously discussed many cases involving mobile homes where we know a person has a reduced expectation of privacy. But there are two reasons why that is. Number one, the fact that mobile homes, like other vehicles, are readily mobile, meaning that it would be difficult for police officers to obtain a search warrant before the vehicle would drive off. And the second, perhaps even bigger reason, is the fact that mobile homes and vehicles in general are heavily regulated by the government. So in this case, the Ninth Circuit concludes that a tent is more like a house and not as much like a vehicle. And so the Fourth Amendment did in fact apply, and the warrantless search of the tent on a public campground did in fact violate the Fourth Amendment. Now let's move on and talk about the initial arrest. How does the Fourth Amendment apply in that situation? Well, we know that no warrant is required to arrest a suspected felon in a public place. But absent exigent circumstances, a warrantless arrest is unconstitutional in a non-public place, even when that place is not one's residence. Even though Guch's tent was pitched on public property, the Ninth Circuit determines that a closed tent will be deemed a non-public place for the purposes of the Fourth Amendment. That is because a camper should have a reasonable expectation of privacy, and a legitimate one, when he stays in a closed tent on public campground. The Ninth Circuit says there really shouldn't be a difference between an individual traveling to Yellowstone National Park and staying at a hotel versus a tent next door. Both individuals should enjoy a reasonable expectation of privacy in their dwelling, even if it's a temporary one. So, long story short, the Fourth Amendment applies because you should have a reasonable expectation of privacy in your tent. Just like the officers cannot go into your house to make an arrest without a warrant, they're not able to go into your tent and do the same. Now let's discuss some of the exceptions to the Fourth Amendment warrant requirement. We know that over the years, the Supreme Court has discussed a number of exceptions. One of those is called exigent circumstances. Exigent circumstances are those in which a substantial risk of harm to the persons involved or to the law enforcement process would arise if police were to delay a search or arrest until a warrant could be obtained. Exigent circumstances are present when a reasonable person would believe that entry was necessary to prevent physical harm to the officers or other persons, the destruction of relevant evidence, the escape of the suspect, or some other consequence improperly frustrating legitimate law enforcement efforts. The Ninth Circuit determined that there was no independent indication that the firearm would be destroyed, nor could it even be removed from the tent with the officers present. There was no actual ongoing threat. The district court properly found that the campground appeared quiet when the officers arrived in daylight hours. This means there was no exigency that prevented the officers on obtaining an arrest warrant. But what about a search of the tent? Well, similarly, the Ninth Circuit here says that the search was also not justified under exigent circumstances. At the time of the search, the defendant was in custody, handcuffed, and locked in the back of a patrol car. He was not a danger to anyone, and he was the only one that the deputies had any reasonable grounds to believe had violated the law, or that he was the individual that could possibly have been a threat to them. In the instant case, no one remained in the tent at the time of the search. It would not have been difficult to prevent children or anyone else from entering the tent until a warrant was obtained. And so, if you think about it, in this situation, it is simply not logical that officers didn't have time to obtain a search warrant because of the firearm, because if that was the case, the officers could always claim exigency in any case involving firearms. So the only other exception that's left is search incident to a lawful arrest. A lot of times individuals call this search incident to arrest, but that is not proper. Really, the change here, or the exception, is search incident to a lawful arrest. And in this situation, we have previously determined that the arrest was not lawful. It was in violation of the Fourth Amendment. So this exception does not apply. I hope you enjoyed this video. I hope you learned a little bit more about the Fourth Amendment and how some of these exceptions apply, and the fact that you do have a reasonable expectation of privacy in a tent pitched at public campground. If you like this video, please give it a thumbs up. Please share it with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to lawstash.com and checking out some of the merch. Thanks for watching.